Hello, my name is Kieran Breheny. I'm an associate solicitor here at TLT, and this is a bite-sized session where I'm going to be talking through the changes which the new Procurement Act 2023 introduces in respect of notices. With that in mind, let's have a look at the agenda for today. Over the next 15 minutes or so, we're going to be having a look at the different types of notices, which notices are mandatory or optional. We're going to be having a more specific deep dive into certain notices, when they need to be used and what information they should include, and what are the impacts for contracting authorities of getting the notification requirements wrong. On this slide, we've done an overview of the different types of notices under the Procurement Act 2023. We've split it into different stages of the procurement life cycle. So these cover the types of notices you'll expect to see coming from contracting authorities. So first of all, under procurement planning, when the contracting authority is planning the procurement and looking to give notice to the market of an upcoming opportunity, you may expect to see a pipeline notice, plan procurement notice, and preliminary market engagement notice. Then looking at advertising the opportunity, so the contracting authority is looking to kickstart the procurement. Then depending on the type of procedure that is being utilised by the contracting authority, you'll expect to see one of the following. So tender notice, transparency notice, below threshold tender notice, and dynamic market notice. Then, once the contracting authority has made their decision to award as part of the procurement procedure, then you may expect to see these types of notices. Certainly the first two, so contract award notice and contract details notice. If the contracting authority is not progressing to an award following advertising a procurement opportunity, then you will expect to see a procurement termination notice. And you may also expect to see the publication of KPIs in certain circumstances. Then once the contract's been awarded and that contracting authority is in management mode, then you may expect to see these types of notices published by the contracting authority. So payment compliance notice, contract performance notice, contract termination notice, and contract change notice. So we've shown you the different types of notices that you'll expect to see at different stages. So now let's have a brief look at which of those notices are mandatory or discretionary. As a rule of thumb for the Procurement Act 2023, the majority of the notices are in fact mandatory, or at least mandatory when certain conditions are met, or for certain types of contracts or contracting authorities. Just to flag, unlike under the previous legislation, so public contract regulations, utility contract regulations, whatever it might be that you did in fact use, all types of contracts and contracting authorities are now brought under the one banner of the Procurement Act 2023. So instead is what you'll find under certain sections. So for example, transparency notice, you'll find an exemption as to the type of contracts and contracting authorities that the notice does not apply to. Look, just flagging the plan procurement notice. So this is one of the only truly blanket discretionary notices for contracting authorities. It is down to the contracting authority to decide whether to publish this. Once published, it gives the market a little bit more specific detail of an upcoming opportunity. And this is in contrast to the pipeline notice, which might only give a headline about an upcoming opportunity. You may also find that contracting authorities benefit from a reduced tendering period if they opt to use a planned procurement notice. Also to flag, a pipeline notice is mandatory in certain circumstances. So it's mandatory where the contracting authority anticipates the total annual spend being over £100 million. Now, government guidance does recommend the contracting authorities publish the pipeline notice in other circumstances. So, for example, where the anticipated spend is under 100 million, but the opportunities that are upcoming may be of specific interest to small to medium-sized enterprises. But certainly for suppliers, the expectation or the kind of standard approach for contracting authorities you should expect is that they will publish this notice when their anticipated spend is over £100 million. Now let's have a further look at a few more notices and whether they are mandatory or discretionary. I just want to flag the contract details notice and the requirement to publish a copy of the contract. So the contract details notice is published once the contract has been entered into by the contracting authority. This is mandatory except for certain carve-outs, so where the contract is for private utilities or where the contract was awarded under a user choice direct award justification. Now, those specific carve-outs for private utilities and user choice also apply to the requirement to publish a copy of the contract, but there is an extra condition before this requirement becomes mandatory. So the condition is where the contract value exceeds £5 million. And now let's have a look at the final slide, which details which notices are mandatory or discretionary. I just want to again flag the contract change notice and contract termination notice, both of which we'll look into in a little bit more detail later on in the presentation. The contract change notice is now mandatory for all types of modifications, but there are carve-outs where the contracting authority does not need to publish. So where the contract is a light touch contract, defence and security, or the contracting authority is a private utility. Contract termination notices are also mandatory, except for where the contracting authority is a private utility, or again where the contract is awarded under a user choice direct award justification. And this is a new type of contract that is triggered when the contract ends under a number of circumstances. As I said, we'll look at these in a little more detail later on. So now let's have a deep dive into 6 specific notices under the Procurement Act 2023 that will have a particular impact upon the market moving forward. So first of all, having a look at the preliminary market engagement notice. So this must be published where contracting authorities carry out preliminary market engagement, except where the contracting authority considers there is good reason for not publishing, in which case those reasons must be set out in the tender notice. Now, the guidance coming from central government is that contracting authorities should use this notice as a way of inviting suppliers to engage in preliminary market engagement. So certainly suppliers should keep an eye out for these notices being published, which will give you notification of an up and coming engagement opportunity and will give you time to prepare as best as you possibly can for that opportunity. The notice itself must set out the date the engagement will take place or did take place if the contracting authority is publishing it retrospectively after engagement, and also a description of the type of engagement. And this is particularly important where a contracting authority is publishing retrospectively after engagement, as they will need to include the information that was shared with those suppliers that they engaged with, and also share the outcomes that came out of that engagement. Now, having a look at the tender notice. So this is the notice now that kickstarts open or competitive flexible procedures. So in relation to open procedures, this notice will be used to invite suppliers to submit a tender. And for competitive flexible, it will be used to invite suppliers to participate in procedures or invite them to submit their first or only tender. Now, there's a lot of information that needs to be included in tender notices, and this slide just sets out a small proportion of that information. But certainly notices must include the procedure that is being used, the contract subject matter, the estimated contract value, the award criteria, how tenders may be submitted, and information on lots. Now, contracting authorities can use associated tender documents to supplement the information required for tender notices. And they either need to include the associated tender documents as part of the tender notice when published, or they need to include an indication of where the associated tender documents can be found. Finally, let's have a look at the contract award notice. So this notice must be published before a contracting authority enters into a public contract. Now, unlike under the previous legislation, it is now the publication of this notice that triggers the commencement of a mandatory or voluntary standstill period, as opposed to a standstill letter. And a contracting authority cannot enter into a public contract during a standstill period. Now, for certain types of contracts, so where the contract is light touch or awarded via a framework, dynamic market, or direct award justification, contracting authorities may have a voluntary standstill period of a minimum of 8 working days. For all of the contracts, though, a contracting authority is required to have a mandatory 8 working day standstill period. The notice itself must set out the intention to enter into the contract, and additional information is required where the contract is worth more than £5 million in value. So the number of tenders submitted and name of each supplier. So certainly for unsuccessful suppliers, a lot more information is going to be shared about your involvement with the procurement compared to under the previous legislation. So now let's have a look at the final 3 notices which we'll be looking into as part of this presentation. So firstly, the contract performance notice. So contracting authorities are now under an obligation to set at least 3 KPIs where the contract value is estimated to be more than £5 million. And they also need to publish those KPIs. So where the contracting authority is required to set KPIs, it must publish an assessment of those KPIs once in every 12-month period during the contract life cycle as part of a contract performance notice. Now, the assessment must set out suppliers' performance in accordance with prescribed ratings set out in the Procurement Act Regulations 2024. Now, these prescribed ratings are relatively familiar for a lot of contracts, so good, approaching target, requires improvement, etc. And it might be that contracting authorities amend their draft contracts to reflect these prescribed ratings if their current drafting doesn't quite. So certainly the takeaway for suppliers is that a lot more information is going to be shared about your performance linked to KPIs under a contract, and that information is going to be shared on a much more frequent basis to the market and to the public. Now looking at the contract change notice. So contracting authorities must publish this notice prior to making a permitted modification, and this is now for any of the modification grounds provided by the Procurement Act 2023, unless exemptions apply. So under the previous legislation, only certain modification grounds required the publication of a modification notice. So for example, unforeseen circumstances and where the contracting authority was purchasing additional goods, services or works. Now, the exemptions from the requirement to publish a contract change notice is where the modification increases the contract value by 10% or less for goods and services, or 15% or less for works, or also where the modification increases or decreases the term by 10% or less. There is also an exemption where the modification is to a light touch contract. The contract change notice needs to set out which modification ground is being utilised, the details of any change to the contract, and also contracting authorities will need to publish the modified contract or modification where the contract has an estimated value of £5 million or more. So again, certainly for suppliers and contracting authorities, a lot more information will be shared to the market now where the public contract is being modified under any circumstances. Lastly, let's have a look at the contract termination notice. So a contract termination notice must be published within 30 days from the date the contract was terminated. The utilisation of termination, though, in the actual notice title is a bit of a red herring because it also includes circumstances where the contract ended through rescission, expiration, discharge, setting aside. Where the contract was in fact terminated by contracting authorities, they must include the reasons why it was terminated, an explanation of any breach or failure to perform by the supplier, and any relevant damages as well. So again, for suppliers, if a contract is terminated, the public and market is going to be much more informed about the circumstances as to why that contract was terminated and the supplier's performance under the contract. So let's briefly have a look at the consequences for contracting authorities of getting the notification requirements wrong. So a contracting authority's duty to comply with the publication of notices is enforceable in civil proceedings under the Procurement Act 2023. So what this does is entitle UK or treaty state suppliers who have or are at risk of suffering loss or damage to bring proceedings against contracting authorities. On the slide here, we've set out a non-exhaustive list of the potential consequences of a successful challenge. At an interim stage, this might include an order suspending a decision of the contracting authority. At a pre-contractual stage, it might include an order setting aside the decision of a contracting authority. And at the post-contractual stage, it may include an order setting aside the contract itself. Now, it may be difficult for suppliers to show the failure to publish a notice has itself caused loss or damage. But what suppliers might be able to show is that certain consequences have resulted from the failure to publish that causes loss or damage. So, for example, a breach of a contracting authority's obligation to share all relevant information with the market. It can also have other consequences, so decisions of contracting authorities can also be subject to judicial review, and also failure to publish notifications when required may also cause reputational damage for contracting authorities and may ultimately put the procurement in jeopardy. If you have any questions, please do not hesitate to contact myself or any of my esteemed colleagues shown on the slide here. Finally, just a quick plug for our Procuring 360 initiative, which is TLT's support package for both contracting authorities and public sector suppliers in terms of getting ready for the new Procurement Act 2023. TLT are able to offer a wide range of support, not just legal, but also technical, consultancy, and more practical support. So do check our website or contact a member of the team if you require any further support in relation to getting ready for the implementation of the new Act. Thank you.